We are an asset protection and estate planning firm, the Presser Law Firm in Boca Raton, Florida. I have been an attorney for over 25 years, specializing in estate planning and probate and asset protection. Today what I want to talk about is what happens when you have an estate, you either have an estate plan that you didn't do correctly, or if you don't have an estate plan at all. And then I'm going to end with some fun facts, maybe not so fun for them, about estate planning mistakes made by celebrities. So what we're going to cover today is failure to recognize the importance of estate planning when you have no estate planning at all, when you have an estate plan but you don't understand it, doing it yourself, the consequences of the poorly prepared estate plan, choosing the wrong person to handle your estate, inflexible planning, finally, the estate planning mistakes of celebrities. So the first thing that's most important is that you need to know what estate planning actually is. Estate planning is the process of making sure that your assets are transferred at your death to whomever you want them to go to, that in the event of your incapacity, you have somebody who's able to handle things for you and make sure that you're taken care of. And that also includes both at death and during life. If you become incapacitated, what happens to your minor children or incapacitated children if something happens to you? Who's going to take care of them? And it's so important to know what would happen if something happens to you and to make sure that you cover all of these areas. So the very first thing I want to talk about is if you don't have an estate plan that you've actually consciously created, you may actually already have done a little bit of planning that you don't know about. So let's just say you have a bank account, and in that bank and on that bank account you have a listed beneficiary. So if something should happen to you, if you die, the account is going to go to your daughter. Well, that's actually partial estate planning, because if you die, it automatically goes to your daughter upon presentation of your death certificate to the bank. It may not be the best plan. If you knew what the ramifications of it were, you may not have chosen that, but at least you've done some sort of planning. Same thing with life insurance and retirement benefits. If you do have beneficiaries listed, then you've at least taken a little bit of a step to move towards an estate plan. Let's just say you have an asset, maybe your home, that's titled as joint tenants with rights of survivorship with someone, whether it's with your spouse or with your children or with any other person. That's also a means of estate planning, because by having it with rights of survivorship, so should something happen to you, then the other person inherits the asset without having to go through the court, to go through a probate process. Now, let me just tell you a little bit about probate. It's a word that many people have heard, but not everybody really understands. Probate is the court process that is necessary to transfer assets from a deceased person to their heirs or beneficiaries. The difference between heirs and beneficiaries is beneficiaries are the people you've listed on your will or your trust, whereas heirs are the people who inherit if you don't have that will. Probate is going to be necessary whether you have a will or you don't have a will, as long as you own an asset that is in your individual name at your death. So what does that mean? Let's go back to the bank account. If I have a bank account and it's just in my name, I don't have any beneficiaries listed, and there's no joint owner with right of survivorship, then that account, in order to get from me at my death to someone else, needs to travel through the probate court through a designated process where the title can ultimately be changed, the account liquidated, and the account put into the name of someone else or multiple people. The only way that is going to happen is for us to follow the process, which means paperwork has to be filed with the court, creditors have to be paid, attorneys have to be paid, accountants, potentially appraising assets. A lot goes into the process of probate. It takes time, it's expensive, and can create a lot of drama. So it could be a long time before somebody ever sees any of the assets. And we're going to talk about that when we get to the celebrity mistakes. So probate is not necessarily the best thing. It may not be what somebody would ultimately want, but it is necessary if there's any asset owned individually with no beneficiary and with no right of survivorship. So you have to go through that process in order for it to get to the people who are going to inherit. If you had a will, then the people who are going to inherit are your beneficiaries listed under the will. If you have no will, then it's going to go through what we call intestacy, which is every state has some statute that designates if a person dies, who's going to inherit their estate under intestate succession. I'm going to go into that a little bit more shortly. So you have to understand what the estate planning is all about in order to understand whether you've done it right, not done it at all, or can do better. So let's say you have no estate plan. Well, first thing we're going to look at is what have you done accidentally? Do you have beneficiaries listed? Do you have any assets that are joint with rights of survivorship, or if you're married, tenants by the entireties? Well, if you do sort of have an estate plan. It may not have been a conscious one, and it may not be the one you would want, but it's some sort of plan. If you don't have one, then what you need to look at is what would it take for you to make a plan, and what would you be accomplishing by creating a plan? So if you have no plan and you decided you wanted to make one, well, what would you be able to do? Well, for one thing, you'd be able to choose who would actually be in charge after your death of your assets and making sure they get distributed properly. That's what we call a personal representative, and in some states it's called an executor. Those are the people that are appointed by the court to handle your probate estate. This is not your assets that don't have to go through the probate court, just the assets that do have to go through the probate court. So the court is going to appoint someone, whether you have a will or you don't have a will. If you actually have a will, you can decide who that person is. There are some limitations depending on where you live as to who can serve, but in general, as long as you're educated in who can be a personal representative or executor, then you can be the one who chooses them and puts that down on paper. The advantage of being able to choose that person is you can know what type of person is going to be the right fit, who's going to be able to deal with the beneficiaries, deal with the court, et cetera, et cetera. The other thing you're able to do in an estate plan and in a will is to choose a guardian for your children, for your minor children. If you die without any sort of plan, then what happens to your children? Who's going to take care of them? How are they going to get money? How is the guardian going to get money to support the children? Do you want people fighting over the children? I had a case very early in my career where it was a very unfortunate situation where I can't remember if it was the father or the mother, but I think it was the father who ended up in jail and the mother ended up comatose. And there were two young children, and both sides of the family were literally fighting over those children and where they would live and who would take care of them. And it became a very ugly situation, which had the parents had some sort of documents in place, they could have designated who would be in charge, and there might have still been some family harmony. In the end, one party won, and the other party, and the families didn't communicate. So the children are the ones that lost out. So having an estate plan in place gives you the opportunity to name those guardians and hopefully inform the families in advance so nobody's really surprised. In addition, if you have no estate plan, if you have no will, then anything that a minor child, usually under the age of 18, would inherit has to go through a court guardianship. And then at the age of 18, those children can stick their hands out and say, okay, I'll take my money now. Well, most children are still in high school at the age of 18. They're just graduating high school. What are they going to do with a large sum of money, which they could potentially inherit? it's a disaster. So if you have an estate plan, then you can designate different options for how the children can get money, whether it's in trust, whether it's through a custodian. There's a lot of different methods that can be used, and it's the same if you have a beneficiary who's disabled and shouldn't be managing their own money. So there's a lot you can accomplish by actually creating that estate plan. And then finally, if you do things in such a way using trusts that you can avoid probate completely, then you're going to save a lot on legal fees, time. It could take months or years for probate to go through before anybody even sees any money. The estate can be very largely depleted by any costs that are involved. So if you do plan your estate, you have ways to actually minimize all of those things. Well, let's say you actually went to an attorney and you actually did an estate plan. And I see this absolutely every single day. People who have gone to an attorney, done their estate plan, but they really have no clue what it said. They may have gone through the work at the time of, going over everything and answering all the questions that the attorney asked them, but now it's 2, 3, 5, 10 years later, and they really don't know what it says. So they don't know if it meets their current needs. They don't know exactly what's supposed to happen. So I see this every day, and I'm sure it happens with, my clients who I did the original plans for as well. But it's really important to actually understand what your plan says, which means maybe meeting with your estate planning attorney every, 1 to 3 years, just to go over it. Make sure it says what you want it to say. Inform your attorney that if there are any changes in your family situation, in your financial situation, in your health situation, because maybe the plan needs to be changed. So if you have a plan, that's wonderful. You're 10 steps ahead of the game. But it needs to be a living, breathing plan that changes over time and can be flexible. And we're going to talk about flexibility in a little while as well. But when you want to understand your plan, the two main things you want to know are, okay, if I become incapacitated, who's going to take care of me? Who's going to manage my money? Who's going to make healthcare decisions for me? If I have to be declared incompetent by a court, who's going to serve as my guardian? Is it going to be the same person who's going to be in charge of where I live and making sure that I get health care as the person who's going to be in charge of my money? Doesn't have to be. You can have different people. So part of your estate plan is not just what happens after I die, but it's what happens to me if I become incapacitated. Who's going to be guardian of my children if I can't take care of them, even if I'm still alive? All those things are necessary in an estate plan. We don't just worry about what happens after we're gone. We must worry about what happens if we're still alive, but unable to handle things for ourselves. And then, of course, the second part is what happens if I die? Who's getting my money? When are they getting my money? Can I control how they get their money? Are there limitations? What happens if they get divorced? Do their spouses get the money? All those things have to be in your estate plan and contemplated. What happens if I have more children? Is that covered in my estate plan? We're going to learn about Anna Nicole Smith, how she made that mistake and it wasn't covered. I've had many people over the years come to me and say, oh, we just had a new baby. We need to update our estate plan. I say, okay, let me take a look at it. And then when I look at it, if it's done properly, then you don't even have to update it. It should be covered in your estate plan that future children and descendants are covered under a good document. But you need to know that. So that's why you need to revisit that plan every 1 to 3 years to make sure you always understand what it says. Because you should be thinking, just like those people who come to me after the new baby, you should be thinking, uh-oh, do I have to update my estate plan? The great thing is if you did it right the first time, you don't have to, but you shouldn't be the one making that determination. You should know that you have somebody you can rely on, who you can go to, and that person can share with you, here's what your documents say, you don't need to update, or you do need to update. These are my favorite, the do-it-yourself estate planning. Now, there are some really good companies out there that create pre-fabricated forms, I guess you can call them. You fill in the blank. That's one option. The problem with those fill in the blanks is that you're not a lawyer. And if you put in even one wrong word in those do-it-yourself forms and the wills and the trusts, it could mean something completely different than you intended. And I can tell you, as an attorney who does this all day long, I've thought long and hard about these forms, and I can't personally think of a way to put in enough information in the template of the forms and in the instructions to make sure that if somebody were filling it out who doesn't know the laws, that they'd fill it out always correctly. I can't say I haven't seen any that have been done correctly. I have. But there's always that potential for error, which as an attorney makes me very worried. So in some cases, I would tell you on some forms that, filling those out is better than having nothing at all. And sometimes that's correct because there are certain forms that it's kind of hard to mess up. Generally, the healthcare surrogates and the living wills and the durable power of attorneys even are not that difficult. Those forms are usually pretty decent. And those are probably better than not having the form at all. A will or a trust, I would say you're probably better off not doing them, because if you do it wrong, it'll just mean something completely different. Now, if you're an educated person in terms of knowing what an estate plan is and what your options are, as well as what would happen if you have no plan at all, who would inherit under the state law, then you may be able to pull those documents off and it'll be okay. But I kind of, advise against doing the will and the trust on your own. Again, you want to try some of the minor documents like the power of attorney, healthcare surrogate. You may be okay, not a guarantee, but you're probably, it's hard to mess those up because it's usually just filling in names and addresses. But be very wary of the other documents. Now, if you mess it up, then it can be very costly, because if you use the wrong wording, it could be the wrong people are inheriting, or worse yet, if it's so ambiguous and you can't really understand what you were saying, then if there's multiple people who are going to fight over it, then it's going to be a will contest, and then it's going to cost everybody a lot of money, a lot of attorney's fees, a lot of time, and the estate just gets used up from the legal fees before anybody ever gets anything. So just kind of keep that in mind if you were thinking of doing it yourself. And me, I'm an estate planning attorney. I have a master's in estate planning. I've been doing this for over 25 years. I don't even do my own estate planning, because you just don't, just like a doctor shouldn't treat themselves, a lawyer, unless it's the minor stuff, should not really be doing their own work. So keep that in mind when you're thinking about whether or not you should be doing your own documents. So now what happens if you've created that estate plan, but it's not the best? It's just not, whether it was a good plan at the time or whether it was a bad plan at the time, either way, today it's not necessarily a good plan. What are the ramifications? Well, the first major hit is going to be the taxes. If you have an estate that is taxable, then if your estate is not done properly, either you don't have an estate or no tax planning has been done, then there's going to be a huge amount of taxes that need to be paid. And what I'm talking about in terms of taxes is not necessarily income. What I'm talking about is the estate tax, which is a tax that is assessed on the death of someone, on all their assets, no matter where they're located. So if you are taxed under the U.S. tax code, then if you own assets outside of the U.S., they're still taxed at your death. And 9 months from the date of death, come hell or high water, those taxes are due, which means that all the work has to be done to calculate the assets and figure out what they're worth and how much tax you have to pay. And that amount of money has to be remitted to the government 9 months from the date of death. You can get an extension on the actual return, just like you can with any other tax return, but you need to have paid your estimated amount because there's high interest and penalties. Without going into too much detail on estate taxes, the rate right now is essentially 40% of your taxable estate is what you have to pay. So if your net taxable estate is $10 million, well, no, let's not use that because there's an exemption. Let's say your estate is $20 million and there's an exemption, which you can take off the top right now of $11.2 million. That leaves you with $8.8 million of a taxable estate. 40% goes to the government. That's a huge amount of money. There's a probability that you could have planned ahead and saved a lot of that going to taxes. Another thing that happens from a poorly prepared estate plan is that your beneficiaries can lose their inheritance to the spouse or creditors. So what do I mean by that? Well, in a simple situation, if somebody inherits your money, if your child inherits your money, they're going to put the money in their bank account, and then if they get divorced or they get sued, then that money is available to the ex-spouse or to the creditors. It's very simple. If they keep the money separate and never commingle it with a spouse, then there's a good shot that the ex-spouse can't get to it directly, but they can probably get to it as an allocation for child support and other sort of support. So it may not be a split at the time of divorce, but it's definitely going to go into the financials as to available income and available assets. For creditors, well, if I owe you money and it's in my own name, you can get it. If you have a trust and the trust is done properly, then there's a way to protect beneficiaries from the spouse or from the creditors from getting the money. It's called a spendthrift clause. Again, a little beyond today's scope, but there are certainly ways to protect the beneficiaries from themselves, from their creditors, and from their spouses. If you don't make a plan, then it's all open to everybody getting it. So no plan, they're subject to creditors and spouses. If you make a plan, if you plan it correctly, then you can protect them. In the poorly prepared estate plan, the wrong people may end up inheriting. We're going to talk later in Celebrity Mistakes about Marilyn Monroe and who her estate went to. She didn't plan correctly, and therefore it ended up going to a stranger. Or let's say you didn't want it to go to certain people, but you didn't plan ahead, you didn't disinherit them, you didn't direct the money. They're going to inherit. That's not what you wanted. We already talked about the high cost and lengthy time it takes for probate. If you had done a trust, instead of just relying upon a will or nothing at all, you might have been able to avoid probate. Your beneficiaries would have gotten their assets and money quicker. It would have been less costly in terms of attorney's fees, and it would have been a lot easier. And the beneficiaries can get money over time instead of just getting everything at one time. If you plan in trusts, again, for your beneficiaries, you can keep creditors from getting at the assets. The other thing that I mentioned earlier is when you go through probate, you have to pay off your creditors. If you don't have to probate your estate because you just do trusts, then if your creditors don't come forward within 2 years, they're not going to get any assets. They're not going to get paid. With probate, you have to publish to creditors and let them know. With trusts, you should publish to creditors just to get the time barred and start the clock. But if you don't, then they really only have 2 years to come forward, at least in most states. So there's no requirement for you to publish. Therefore, you could go under the radar. And then lastly, depending on how your beneficiaries or heirs are getting your money, if they're getting it outright because you didn't plan for them to get money over time, once they have it, it's theirs and there's no control over it, and therefore they're just going to use it and spend it and then it's done. Whereas if you create that plan and you put it in trust, you can actually stagger how long it takes them to get money and how they get money, and let the money work for them instead of it just being a one and done type of thing. So there's just a much better play if you do a properly planned estate plan. We talked a little bit before about who is going to administer your estate. If you have a plan, then you can at least name the people who are going to be in charge. So if I do a will, I can name my personal representative and successors. If I do a trust, I can name my trustees. If I do a healthcare surrogate, I can name who makes my healthcare decisions. Same thing for a power of attorney, who's going to make my financial decisions and sign things for me if I become incapacitated. So by doing a plan, you have the option of choosing these people, which is great, but there's a lot of power in making those choices. So who are the right people? Who's the right person to be your healthcare surrogate? Well, that person's got to be somebody who can make decisions based on proper advice. They know who to go to get the proper advice. They're not so completely ruled by emotion that they're unable to make a decision, life-threatening decisions and life-saving decisions without being too emotional to be able to handle it. It has to be somebody who can resist your other relatives. That's really critical. A lot of people don't think about that. If you choose the wrong person to make your healthcare decisions and the family is so aggressive and they bully the person making the decisions, well, that person might not be making the decision that you would have wanted because they're being bullied and influenced by others. With financial, if you're incapacitated and can't make financial decisions, you may name a power of attorney. Very important document to have, which is a power of attorney. But it's a very scary document because if you name someone while you're alive to be able to sign things for you, well, what if that person decides to run away with your money? You've basically given them the license to steal. Sure, you can sue them, but at that point your money's already gone. So you want to make sure to have the right person step into your shoes to make those decisions and sign that paperwork. After you're gone, you could say maybe it's a little less important because you're not around, but that's not true because the person who's in charge is the person that's handling things for your beneficiaries. So did you choose the right personal representative? Do they have good organizational skills? Because they're going to have to figure out everything you have, put it all together, give the attorney all the information, start selling off assets, distributing out to beneficiaries, and they're just going to have to step in your shoes and make decisions for you. Do they have a way of dealing with the beneficiaries? Are the beneficiaries going to try to influence them and make trouble? Certainly could happen. So you need to choose very carefully who's in charge, who's the personal representative. And the trustee, that one's critical. The word trustee itself is exactly what the whole thing is all about. This person has to be trustworthy. They are in charge. They can be in charge for the long term in terms of assets, how the assets are going to be distributed, depending on how you phrase their powers in the trust. Do they have discretion over how to distribute? What kind of decisions do they have to make? They have to invest the money? They have to manage the money? There's so many important requirements of a trustee that you really must choose the right person or persons. You may want to choose multiple trustees. Again, that's kind of beyond the scope of today's webinar. I've done others on trustees and on trusts, and we'll probably do additional ones. So we can talk about that at another time in length. But choosing the right person to handle your estate and all aspects of it is absolutely critical, because without that, all the estate planning is completely wasted. Now let's talk about inflexible planning. Let's say you've done your planning, which is great on the first step, but what you've done doesn't allow for changes. So how would we have that? So there's two opportunities where that would happen. Number one, if you create a trust, and that trust is called an irrevocable trust, meaning you create it, but you can't change it. It's not revocable. It can't be terminated. It can't be changed. It's great for getting it out of your estate for estate taxes. It's great for creditor protection of you. However, you no longer have control over it, so you no longer can benefit from the money. But more than that, once you create that trust, if it doesn't have flexibility, you can't change it. And what if you want to change the beneficiaries, or you want to change some of the terms of the trust? You won't be able to. So that's one thing that could happen. If it's an irrevocable trust that you set up during your life, even when you're alive, you might not be able to make any changes. And I'm going to tell you how we can get around that. And then the second one is even a trust that you create during your life that's called a revocable trust, which is a trust that you create that you're allowed to change. You can get rid of it if you want. You can use the money as you will. The minute you die, it becomes irrevocable, and you're back in the same position as we talked about with the irrevocable trust. So that's what I want to address. So if a trust is irrevocable, whether it's while you're alive or after death, you want to make sure that you have the most flexibility. You want changes to be able to be made. Normally, that's not allowed, but there are ways around it. Why would you want to make changes? You'd want to make changes if the tax laws change. We just had a major change in estate tax laws. The federal exemption went doubled. So that makes an estate plan, it could be completely outdated depending on how much somebody has in assets. So we want to be able to do some modifications to reflect the tax laws and maybe change how things are being distributed, because we no longer have to worry about the taxes because the exemption is so high. Or vice versa. What happens if we plan today based on an $11.2 million exemption, and then in 2026 it goes back to $6 million, which it may very well happen? What if you want to change your beneficiaries? So you make your plan in the year 2000, and you named all of your children as beneficiaries, and for whatever reason you said if the children passed away, it went to their spouses. Well, and today you're looking at their marriages and you're not so pleased with the marriages. You don't want the spouses to get the money. Well, what if you want to change beneficiaries? Or if you want to change how the beneficiaries are getting the money? I see this all day long. 20 years ago, we used to plan, it was very common that we'd plan that after the parents died, that the kids would be able to get money from their trusts. They'd get a third of their trust at age 25, half at age 30, and then the balance at age 35. And that was really very common planning. Nothing wrong with it at the time. But when we look at it today, where everyone is being sued for everything else, the divorce rate is so high, if you have such a plan, then once they're at that age, at 25, 30, and 35, they must get that distribution, which means if a creditor is out there, they've got a judgment against them, the creditor will say, great, you're turning 30, happy birthday, let me have my money. If they're getting divorced, the spouse is going to say, great, you're due to get a distribution at age 30. Judge, they're getting a distribution, that's additional assets. We're going to calculate that in terms of ability to pay alimony and child support, et cetera, et cetera. So maybe we don't want to make it so that they get the money. We want to make it so maybe they get the money. Let the trustee decide. Let the trustee kind of look around. You know, take a barometer of what's happening in the beneficiary's life before they decide whether the beneficiary should be getting the money. If you have an irrevocable trust without flexible planning, you're not able to change any of that. So what we always want to put in trusts and make as part of our estate plan are two things. Number one, we want to be aware of something called decanting, which is basically an ability to take an old trust and morph it into a new trust, pour the assets into a new trust with different terms. Now, there are restrictions on what terms can be changed, but there are certain terms that can be changed in order to create flexibility. So some states allow for decanting, not every state. So one of the things you need to talk to your estate planner about is, do I have provisions in my trust that allow for the trust to be decanted? Whether it's in 10 years, 20 years, 30 years, 100 years, it doesn't matter. You want it to be able to stand the test of time if this trust is going to continue for a while. The next thing you want to do is you want to appoint what's called a trust protector. That's someone who's going to have the ability to make certain changes to the trust. So even if there's no decanting in your state or the jurisdiction of the trust, you could at least have a trust protector to be able to make changes to reflect tax laws, to be able to convert a trust for a beneficiary into what we call a special needs trust if the beneficiary starts receiving government benefits. Because if you receive government benefits and you're entitled to money under a trust, then you lose your benefits, the money in the trust gets dissipated by your needs, and then you're back to square one getting benefits again with no other money available to you. So you want to be able to have some flexibility even with an irrevocable trust. So that's why we have the protector, and which is sometimes called a trust advisor. There's different terms. Protector isn't necessarily the only term for it. And you want to be aware of any decanting statute that might apply. And sometimes you can even choose the jurisdiction of the trust to reflect good trust law and a state which would allow for decanting. There's a lot of different things that have to go into that, but it's certainly something that you should be, talking to your estate planning attorney about. And then, of course, if you can create flexible planning, we're going to be protecting from creditors. So that's really a great tool just to create that flexibility. So now let me give you some examples, some of the things we talked about and how they relate to celebrities. So Marilyn Monroe, famous actress, died in 1962. She set up her assets. She did have an estate plan, and she wasn't married and had no kids, so she left majority of her estate to her longtime manager, which was very nice of her. The problem was she left it outright and not in trust. So when she left it outright and he died, what ended up happening is all of her assets ended up going to, I believe, his third wife, who she had never even met. So there went her assets. Had she set it up in trust so that he could use it for his life, and then at death it went wherever she wanted it to go, whether it was family, friends, or charity, she would have been the one making that decision. Instead, it ended up going to a stranger. Elvis Presley died in 1977, and most of his estate went to pay estate taxes. No proper planning. Joe Robbie, this was a complete disaster. He had an illiquid estate. He owned the Miami Dolphins and the stadium, the majority of it at the time of his death. He had a large family, and what ended up happening is he did not create a proper life insurance trust and fund it with life insurance so that they had the money outside of his estate to pay the taxes. Not to get overly complicated, but what ended up happening is that he left everything. He did a plan, he did a trust, but he had it kind of simply done. And his wife, and this was his first wife, his wife was entitled to all the income from the assets. But she didn't want all the income. She'd rather have a lump sum. So what she did is she opted, which is every spouse's right, to take what's called an elective share against his estate, which meant that she can get 30% outright. But by doing that, she essentially messed up the marital deduction that you get between husband and wife, where you can leave without estate taxes. that was no longer valid when you take an elective share. So now all of a sudden, the assets weren't supposed to pay estate tax until the second one died, until she died. But now they had I believe it was a $47 million tax bill. So that was a complete disaster. He did not have proper planning. And simply doing a life insurance trust outside of his estate and funding it with the proper amount of life insurance would have solved all of that, and the beneficiaries would have gotten so much more money. And they wouldn't have had to sell out to Wayne Huizenga to sell out the stadium and the team, which they ended up doing because they had no liquidity to pay estate taxes, which, as I said, is due 9 months from the date of death. Here's an example of what I talked to you about before, why I don't do my own estate planning. I should never do my own stuff, just like Chief Justice, I don't know if he's a Chief Justice or he was a Supreme Court Justice, Warren Burger, did a 176-word will, and he failed to, it was a will, it was okay, but he failed to provide directions to his personal representative. He didn't do personal representative's powers, and ultimately, it really wasn't a very good document. Shouldn't have done it himself. It was probably the shortest thing he ever wrote, but it was a mistake. Marlon Brando allegedly made promises to his housekeeper that she could stay in the house and, I believe, inherit the house, but he didn't do it in writing. It was oral. Therefore, she did not inherit it, and they had to sue, and it was a long court battle, and ultimately it was a mess. Anna Nicole Smith, she had a very interesting one. She had a will, and she left everything in trust to her one son with no provision for future children. Her one son died right before her, and then she had a daughter right before she died, and there was no provision for the daughter. So it took a lot of legal maneuvers and took quite a while for everything to be decided that it would go in trust for the daughter, but there was no plan for it. So they had to go to court over it. There was a battle. Money, got depleted from the estate. It took time. It was completely unnecessary. She should have had a plan where she provided for future children. Steve McNair, football player with the Titans, he had an intestate estate, and he had given his mother a gift of a house. And in the end, his wife ended up suing the mother for taking possessions out of the house, and it was a big mess and completely, again, unnecessary. I guess he made it big quickly, and he didn't bother to plan his estate, so that was a mess. Michael Jackson, he did some planning. He created a revocable trust, but he didn't put anything in it. So that had to go through probate and long legal battles and fighting over everything to decide who would be in charge and how the money would be distributed. And then the one I don't have here is Prince, who died, I believe, in 2016. I think his estate was worth about $200 million. So far, and I don't know if it has changed recently, no one had gotten any money yet, with the exception of the attorneys, who had made more than $6 million on the estate because he had no will. The court first had to decide who the beneficiaries were. So, of course, there had to be some fighting and people coming out of the woodwork on that one. Probate costs are ridiculously high, and no one has seen a dime, and he's been gone for a couple of years because until that all gets decided in probate, no one's going to get any money. Bottom line is, lots of mistakes can be made. Go to somebody qualified. Make sure you, even after you've been to that qualified person, that you stay on top of it. Revisit it every few years and make sure that you know what your estate plan says. We're going to pause for a moment or two. I want to gather some questions that have come in. So please hold for one moment. Okay, we're back. I'm going to take just a couple of questions today. First question is, well, how do I know if my will is good? Okay, well, little open-ended question, but essentially what you need to do is take it to an estate planning attorney and have them take a look at it. There are things you need to look at. Number one, you need to make sure that it's properly signed and witnessed. Hopefully it's notarized. Depending on what state you're in, you have to look at what the notary and witness rules are, how many times each person needs to sign. The next thing you need to make sure of is that nobody wrote all over it. It's happened to me many times where a client will come in and say, oh yeah, I wanted to make some changes, here's what they are, and they've written all over the original will. That's not good. And then of course you want to make sure that the people that are listed in there are the right people. So that's the basics of reviewing the will. The other question I had was, I have a trust, but I've never actually done anything with it. Well, that's pretty common. A lot of people go so far as to create the estate plan, but then they don't do what we call funding the plan. Funding the plan means actually putting assets into the trust. So what I recommend there is that you make a list of all of your assets and how they're titled, and then generally there's some sort of memo or letter that comes with the trust when you do a trust that kind of directs how to retitle things. And if you have any questions, reach out to your estate planning attorney and they can assist you on that. I want to remind everybody that we do webinars every month. I think the next one coming up is on August 23rd. There'll be a email. It goes out with the newsletter. If you're not already receiving our weekly newsletter, please let us know and contact us at info@assetprotectionattorneys.com, and we'll make sure to get you on it. We also offer preliminary complimentary consultations. So if you have any issues with asset protection, estate planning, probate, feel free to please reach out to us and we'll get you on the schedule and see what we can do for you. I want to thank everybody for joining us today, and we look forward to having you back next month.